turn your mics on, please. Thank you.
Yeah, call it to order. Let's see, we're going to do a, first item is roll call. You want to start down at the end, Tracy, for us?
Tracy Anderson here.
Lynn here.
Kelly Toon here.
Dan Brown here.
Ken here. And Tammy?
Tammy here.
Great, great. And then we'll stand for the Pledge of Allegiance. You might see a flag on your screen there, Tammy.
Okay. Oh, there it is.
Flag of the
United States of America, and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Just got started. Great. Yep, the same. Okay. Next item we're going to do is the approval of the minutes, which were previously circulated. Everybody get a chance to take a look at the minutes, and did anybody have any comments or edits to the minutes? If not, I'll look for a motion to approve. Give everybody a minute. Anybody have any edits or comments to the minutes?
I have one, but it really doesn't. In mine, it mentioned that I had given discussion on a mining town in Illinois. It was a historical town, but we don't need to change anything. I just wanted to clarify.
Okay.
Okay.
Yes.
Anything else?
You did. Oh,
If
wow.
not, I'll look for a motion to approve the minutes.
Second that.
Okay.
I'll do a motion to approve the
I'd
minutes.
like to make a motion to approve the minutes from August 19th.
I will make that motion.
Okay.
I'll second.
All right. Tracy, was that Tracy or Lynn? Lynn, okay. All in favor? Aye.
Aye.
Aye. Any opposed? All right, motion carries. Okay, the next is to look at the agenda for today. Again, that was circulated. We're going to have some training, and we've got some other items on there, including the update on the historic survey from Ron. Any comments or changes to the agenda? If not, I'll look for a motion to approve the agenda.
I make a motion to approve the agenda of September 9th, 2025. Oh, no.
Yes.
Yes. 2025.
I'd like to second that.
Okay, all in favor?
Aye.
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 Any opposed? All right, motion carries. Did you see how that was done? She's really good. Does anybody have a conflict of interest in the matters we're going to be discussing this evening? Okay. Don't see any public comments.
No, online.
Okay, and none online. That brings us to our special presentations. I'll turn it over to Madison.
Yes, so we have Sam Light with CIRSA here today. You should see several handouts in front of you. 3 of the 4 are pertaining to this. I printed both the slideshow that you'll be seeing tonight, and then Sam printed out 2 one-page handouts as well that are handy to reference, not just during this training, but also in your role as a commissioner. So I will actually turn it over to Sam while I get this presentation on screen.
Welcome, Sam.
Thank you. Thank you, Chair. Thank you, Commissioners. Madison, good to see you all. I recognize some faces, and then we have some new faces, right? We have some new members of the HPC.
Yep, we do.
Dan is.
Kind of brand new.
And
And
Tammy.
Tammy as well.
Freshly minted.
And Roberts.
Hi, this is Tammy.
Were you here for the training? You were here? Okay.
All right. Well, congratulations.
Yeah.
And thanks for having me out.
Yeah.
Yeah, we're gonna do some training on best practices for you all as commissioners, and for the folks who were here last year, this will be a little bit of a refresher. For the newer folks, it'll be an orientation to some of the concepts that apply to how we do our job as commissioners, right? And so I want to make the training for you all as useful as possible. So feel free to ask questions as I go through the material. I think Madison printed copies of the presentation slides. So they're there as a resource. So if you have questions on your mind, feel free to ask. Even if it diverts our attention from the slides, I'm happy to ask anything about what we do at CIRSA and how we can be a resource to you all. But just as a reminder, so My name is Sam Light, and I'm General Counsel and Deputy Executive Director for CIRSA. As a reminder, CIRSA is an acronym, stands for the Colorado Intergovernmental Risk Sharing Agency. We in the insurance world really have sexy names, right? And long names. That's why we call it CIRSA. Okay, so we're the town's insurance provider for property and casualty insurance coverage, which means we cover like the property insurance on this building, the automobile physical damage insurance. If one of your cars gets in a wreck, we cover the auto liability coverage. Probably more interesting to you all as appointed officials of the town is we also carry the liability coverage that protects everybody within the organization when they're doing their job, right? When they're performing their duties and they're staying within their scope of their duties. But the liability side of public entity life is interesting. The coverages that we provide, we cover everything from the slip and fall. If somebody, Lacey out in front of town hall, somebody slips and thinks it was your fault because you didn't shovel the walkway in time or what have you. That's a tort claim. They'll bring that tort claim. We'll provide the adjusters and attorneys to defend that. All the way up to maybe you have a hotly contested alteration certificate that you go away from that hearing and nobody's happy. The developer's not happy, the citizens aren't happy, we're frustrated, and somebody says, well, I didn't like that decision, I'm gonna challenge it, right? If they bring a constitutional claim, like a due process claim, or they bring a claim that your decision was arbitrary, then we at CIRSA provide some coverage to defend. The town is an entity, right? And the commission and the council, right, as its governing body and its appointed body, if you get ensnared in that kind of lawsuit. But knock on wood, I bet that's never.
Does that mean also us individually as commissioners in that capacity?
Yeah, it does. Let's take a little side trip and talk about that for a sec.
Okay.
Yeah, because I hope it's not your
That
first.
happens more and more these days.
Yeah, it does happen more and more. I will tell you, luckily, as appointed officials, I think the risks are a little bit lower.
Yeah.
But there are risks for sure. So, yeah, it's a good question. I hope it wasn't your first question for Madison or your town attorney. Who's your town attorney?
Mike Sawyer with Carpenter Hanlon.
Yeah, so Mike, Mike, can I get sued in this job? You're now a government official. You're appointed government official under state law and under the town's ordinances. For purposes of civil rights liability, you're governmental actors, right? So yeah, it's a fair question. I hope it wasn't your first question, but the answer is absolutely. Yeah, and so the question that I'll address is whether you can be sued and be held individually and personally liable for something you do or don't do as a public official. Okay, so here's the good news. We have really strong protection in Colorado for you from that kind of personal liability. And that's good. We want to, encourage you. You're like, this job's stressful enough. If I got all sorts of liability risk, why would I raise my hand, right? So, but the way the protections work is we got a statute in Colorado called the Colorado Governmental Immunity Act. And it basically says this. It says that the town, as the body that appointed you, right, kind of your corporate boss, the town, and by extension, the town's insurer, CIRSA, will defend you and pay judgments entered against you for acts or omissions as an appointed official. Good news. I'm protected, right? And like so many things in life, there's a bit of a catch to that, right? Those protections apply only so long as you are acting within the scope of your employment and not acting in a willful and wanton manner, okay? So I got to break that down a little bit because those two phrases are a little weird. Scope of employment, sometimes elected and appointed officials will say, well, wait a second, scope of employment, that's not me. I'm just a part-time volunteer citizen advisory board member. I'm not a full-time employee like Madison or the town manager, so that concept doesn't work. Yes, it does. The takeaway is scope of employment is simply the phrase that's used in the liability statute, and it means everyone needs to understand and stay within their job description, understand and stay within the authority that they have. As important, if not more important, for risk management purposes, understand and stay away from authority that you don't have, right? And don't attempt to exercise authority you don't have. That would be stuff that's outside your scope of employment. So I'll give you an easy example. Within the town of Minturn's organizational structure, within whose scope of employment, right? Within whose scope of employment, within whose job description is it to decide whether or not someone gets a building permit in reference to the building code, or whether or not somebody gets their building project red tagged because they're not complying with the building code. Whose job is that?
It's either ComDev or the building department.
Yeah, it's your chief building official, whoever that is. Is that you?
Not here.
Not here, somewhere else. Yeah, it's within the scope of employment of the chief building, so whose job ain't it? Well, not only you, but everybody else. It's not the treasurer's job, it's not the clerk's job, it's not the chief of police job, right? So that's pretty obvious on its face, but the risk that happens is if people try to exercise power that they don't have, right? So the other interesting, conversely, within whose job description, in whose scope of employment is it to decide whether or not a certificate of appropriateness is issued for a proposed project affecting a historic property. You. That's your expertise, that's your area, that's your niche. In liability terms, that's your scope of employment, right? Is it within your scope of employment to negotiate and sign a contract on behalf of the town? No. Is it within your scope of employment to go to an employee who's under Madison's supervision and direct that employee do or do something or not do something? Not your job, right? So you can see how the liability protection is easily attached when we're doing our thing. And the other good thing is you do most of your work in this room when you meet together and make decisions on items that come in front of you and on the agenda. Right? You do some ambassador stuff out in the community. You're the eyes and ears of the community around historic preservation, but you're not acting, right? You're just eyes and ears at that point. Your protection, your best liability protection, if you want to act, is remember that you act collectively as a board, right? And your best protections are when you do that in this room collectively, right? Okay. The other weird phrase there is willful and wanton. You're protected as long as you're not engaging in willful and wanton conduct. And that's conduct that's intentional conduct designed to injure someone's legal rights and taken with reckless disregard for what their rights are. And my even simpler way of describing it is I just call it bad stuff. It's bad stuff. We don't get, and knock on wood, we don't get many claims where some frustrated claimant is suing an individual or elected official individually, right, alleging that they engaged in willful and wanton conduct. But we get, a good handful of those every year. And the allegations are, pretty outrageous stuff. Some of them are true, some of them aren't true, right? But my claims people tell me that this is the most common fact pattern where that risk arises. It's where an elected or appointed official, by the way, the same concepts apply to employees too. So Madison knows all this. She's going to stay in her lane as well, right? And that is, it's almost always a situation where an individual elected or appointed official misperceiving that they have some governmental authority that they actually don't have, right? They throw on that purported cloak of governmental authority and begin doing bad things to people for the wrong reasons. And it really would be bad stuff. Using my building permit example, it might be like an elected or appointed official conscripting the building official who's also not thinking about things straight and going on this campaign to make sure that my business competitor doesn't get a building permit for their project for no good reason other than that they're just my business competitor, right? Or, hey, I got some longstanding personal dispute with this person, so I'm going to conscript the police department and try to convince them that they, need to give them a ticket for some nuisance. Or malicious conduct, intentional defamation, right? If you're a hero on the dais, it never happens. Although I've had one lawsuit that did involve this. You get in a heated debate here at the dais with some citizens. Look, you have a legislative and quasi-judicial privilege that protects what you say, protects you from personal liability from what you say, except in the most egregious circumstances. But sometimes it's happened. I've had allegations where an elected official speaking from the dais, but wholly outside anything related to their job, right, now gets in a shouting match with a citizen and defames them by calling them whatever. You think of words that are defaming, criminal, pedophile, tax evader, crook, cheat, whatever. And they said it knowing it was false, and they did it with intent, right, to harm that person in their eyes of the community. That's a personal tort of defamation. That would be outside the scope. That would be willful and wanton. That's where these protections don't apply. So there are ones that are a little more nuanced, and I've got an example of one later that I'll show you. That
We have
help?
what's called the feasances.
No,
The feasances.
what is that?
Malfeasance, misfeasance, and nonfeasance.
Yeah, the feasances, yes. Yeah.
So that's kind of how we grade ourselves on the code of ethics, it's
Yeah.
like,
Yep, yep. I think a good takeaway from a risk management perspective, particularly if things are getting, feeling dicey, is are we doing the right thing for the right reasons through the right process? And if you don't know, that's fine. Again, it's a citizen volunteer position, right? But you need to know enough to know where the risky issues are and then be able to get the appropriate resources for that. So yeah, it might be frustrating, like in the heat of the moment, that the applicant doesn't get a decision tonight, right? But if through the public hearing process, a bunch of issues have bubbled up and it's like, wow, this sounds a little risky. Or we've had some things that come up that were surprises to us and we don't know what to do with this information. Then you always have the prerogative to continue the matter, to the next meeting and get together with Madison and staff and say, wow, that was, they'll summarize all that in a memo and remind you what your options are and what your authority is. The other thing that's risky is sometimes people will invite you and script you into fighting a battle that isn't your battle. And if they're trying to get you to do that as a government official, you got to be careful of that, right? Our interest is the public interest under the ordinances and systems that relates to the regulation, right, of historical properties. We're not here to fight your fight over some private dispute you're having with a neighbor about an easement, right? Or some fight you're having with a contractor, right, about what's owed on the project. Those are your things, but sometimes people mistakenly believe that elected and appointed officials have this extra power to be a fixer for some personal issue that they've got going on. And you want to be very wary of that because that's where you can get exposed, right? Yeah, sometimes people get involved and fantastic, it all worked out wonderfully. But I always remind them, like, did you think about what would happen if it didn't work out well and you were in the middle of that? Would you want to be crosswise of that situation, right? Where all the, in my world, because I'm on the tail end, the claims end of the world. But, if everything hits the fan and then you get ensnared in the litigation, that's not a pretty place to be, right? All right, was that helpful?
oh yeah.
Okay, good. Yeah, we have what's called public officials liability coverage for you. Provides coverage for what we call wrongful acts, right? Because it's possible under our system of justice for us to do all the right things for the right reasons through a fair process, but still face an allegation that maybe we violated someone's due process rights. And some district court judge might even agree with the plaintiff, right? But if it was simply kind of a negligent or an inadvertent, mistaken violation of their rights, that's what insurance is for. Right? And you also enjoy this concept at the federal level called qualified immunity. We hear that a lot in the news around policing, right? But it applies to everybody who's a governmental actor, right? That includes each one of you. And it basically says that we're protected from individual liability for violation of federal rights, right? So long as we are not intentionally violating constitutional rights of people which we knew of or should have known of. I always thought from your perspective, that last phrase is the most interesting one. Should have known. And you're thinking, you get angry applicants sitting there pounding the dice going, if you deny my application, I'm gonna sue you for due process, civil rights violation. And you're thinking, does that have any traction? That last phrase, how do I know? I don't even know. I mean, the whole world of civil rights liability is enormously complex. It's very fact specific. And all you need to know at that point is, hey, we need to get some resources on this and get our attorney involved, help us understand the risks. Is this just pure puffery and we're on solid ground, or does this person have, some colorable claim against us for a due process violation? If so, attorney, write us a privileged memo to make sure we understand the legal principles involved and what our options are, what we can do to steer clear of that risk, right? And if there's nothing more we can do, but we need to protect ourselves, have we properly documented everything we've done and are ready to get started? That's what the attorneys are there for you, to help you with that stuff. So, yep. Never an inappropriate question from your standpoint around risk management, right? If you feel like, as a commission, hey, we need some additional help understanding the risk here. I think that's always a fair question to your staff. Okay, you want to add anything to that? Good, we're
I
good.
think we're good.
All right, all right. I'll just mention it, I'm not sure if I had it on the latest slide, but yeah, I will, I'll skip over there. One area where there's a more straightforward path to individual personal liability is in matters of ethics, right? Because an ethics violation does attach personally. It relates to personal conduct, personal interests, right? If somebody's mad at the decision of the commission, it's very hard for them to say, well, I'm really mad you turned down my application and I'm gonna sue only you. And you're thinking, what are you talking about? I'm just one of 5 or 7 commission members that voted on the application. Well, why me, right? But in ethics, it's different. Like proceeding in the face of a clear conflict of interest and failing to recuse yourself, right? Or inappropriately, if you have a clear legally prohibited conflict of interest, getting involved in trying to influence the decision. That's where somebody, whether we think it's fair or unfair, or whether they're doing it for sport or otherwise, they can, if they want, file an ethics complaint. And then that ultimate liability, if it attaches individually, right? And the employer, your scope of employment employer, the town does not have an obligation, right, to defend against that or pay any penalties. And CIRSA also does not cover ethics complaints.
And so if somebody targets you,
Yeah.
it falls outside of the protection of the town. So it's on you. Like, what does that look like? Because it's different for me, because as long as I act within due diligence,
Yeah.
and I can prove that I did in the best interest,
Yeah.
then I have like a legal standing. What does it look like
Yeah, it
for
depends.
us?
I don't want to get into if you want to drill down a little bit more, ask your staff to support you, because your home rule, and you got your own local ethics code. It's got its own remedial provisions, so I don't know all the ins and outs of that. But I'll tell you how we see it in our claims world. We will sometimes, if an applicant is upset with a denial and they want to go after it and they want to go full scorched earth litigation, they'll file a state law challenge. That can't be brought against individuals. That's just an allegation that the decision was arbitrary. That's just an action against the town acting through its commission. There's no risk of personal liability, right? They feel like there's more going on, like it was a constitutional violation, right? They'll bring both the state claim and a federal lawsuit. The attorneys that practice in this area on the plaintiff side, they like looking for the federal claim because it gives them an avenue to claim attorney's fees and to claim monetary damages, okay? We look at those, and if the allegations basically say that you acting as board members violated their constitutional rights, then we'll defend that claim. But if the allegations also included theories of liability such as malicious conduct, right, or criminal conduct, then we defend those under what's called a reservation of rights, where we say, hey, based on the allegations, there's some allegations against you in your official capacity, there's allegations against you in your individual capacity. We're going to defend until it's either determined by a judge or admitted that the conduct giving rise to the liability was conduct that was wholly outside of your scope of employment or was willful and wanton or malicious or criminal. That help?
Yes, sir.
Yeah, so it's a little disconcerting to receive a reservation of rights letter, right? But that's the way that works. We make a determination. The duty to defend I'm getting into it. You okay with this?
Yeah.
Everybody's eyes are, like, oh my God. Insurance, I get into one point of insurance law. Under the insurance laws that apply, the duty to defend is broader than the duty to indemnify. So if you get a complaint, if the allegations have any thread that might trigger coverage, then we have to defend. But if it turns out the ultimate liability is determined to fall completely within an exclusion, then we don't have to indemnify, okay? So I'll give you the classic police example to illustrate the point. And thank goodness, for police and the wonderful things they do. But this shows you how this principle works in kind of the most dicey situation. We hire and pay police officers to use force in appropriate circumstances, right? But we don't pay them to use excessive force. In law enforcement litigation, we get dozens. We have a couple hundred police cases every year of cases that allege excessive force as a violation of civil rights. But the allegation is they were doing it while performing their duties as a police officer, so we have a duty to defend. But then the district attorney takes an interest in what's going on and saying, well, and I don't think that was not only excessive force, that was criminal. That officer engaged in criminal misconduct, and I'm gonna prosecute that officer for criminal conduct. If it turns out at the end of the day that the civil liability to the plaintiff, right, was wholly caused by conduct that was criminal conduct for which the person was convicted, then we don't have an obligation to pay that judgment. In fact, as a matter of public policy, insurers essentially cannot indemnify people against their own criminal conduct because we'd just be
like you get
financing
out of jail free card.
we'd be financing moral hazard, right? So that's my little trip down the side. So you're gonna see how that principle never gonna apply to you all. And you know what bad stuff is, you're gonna stay far away from it. My main risk management principles are recognize we act collectively as a group. And if we're doing the right thing for the right reasons through a good process, then we're gonna be just fine. We'll never face any personal liability for our work as a commission. And then second, we just need to self-regulate and make sure no matter what the pull and tug and what other people want us to do, we never get pulled into some situation where somebody's asking us to lend our quote governmental authority to something we shouldn't be doing. And we should never have the attitude that says something like, well, you as a commission, you do what you want, I don't like that, I'm gonna do this. That's a red flag. If we go out, strike out on our own, right, because the power of the commission is only held by the commission. All those hundreds of pages of ordinances, you'll never see an ordinance that says the power of the HPC can be exercised by only one member. It's a collective power, right? So if we're working together, and by that I don't mean unanimous votes every time, we're doing our work together, then we're in a good spot. Right? The last one is this, sometimes, this may never lead to a liability claim, but sometimes you have during your meetings, maybe before you adjourn, a little chance for reports where each member gets to make some comments.
Yeah.
Yeah, okay, commissioner reports. Yes, Chair, I've got something to report. You know, since our last meeting, I went out and did this. Everyone's eyebrows go up and go, what? You did what? That may never cause a third-party liability, right, to some outside. But I think if there's that surprise moment, then I think wise elected and appointed bodies recognize, hey, we have an issue here, and maybe we need to talk about what our expectations and norms of conduct are for how we conduct ourselves individually in between meetings, purportedly on behalf of the commission. I say it because I want people to be protected. I've actually had claims in this area where somebody does that. They come back and said, oh, I went to the county meeting or I went to the state meeting and I did this and I told them this was our position and we're gonna do this and the commissioner had never discussed the issue. So the rest of the commissioners are like, well, now I'm a little torqued off because this person's getting ahead of us, purporting to speak for us before we've even spoken. And it went on for a while, back and forth, and they got so fractured that they said, well, I guess what we're gonna do is we're gonna kick the person off the commission. What did the person say? That's a violation of my legal rights. And now we're off to the races with Sursa on an actual claim, right? So I think it's much better to have those conversations early as not in terms of, we're not trying to be punitive, right? Or discount anyone's voice, right? But we're trying to strengthen our group by understanding, collectively how we do great things on behalf of our great commission. And then we don't have surprise moments where there's hurt feelings or friction that bubbles up into even a legal posture. Okay. If I run out of time, you ready? Am I over time? All right, let's do some more. Here's a little bit of, probably this covers the next couple of slides. Let's go back a slide or two. I just want to point out, thank you for that question because it hit on some of these broad themes. I just want to add a couple more. Just recognize, maybe it's a question for Dan or Tammy, right? But this is your second meeting, first meeting?
I guess it would be my second.
Second, right?
Yeah, I went up against the firing squad, I didn't die, and here I am.
Do you agree with this? And this is true, this is of the veterans as well. Do you agree with this notion when you become an appointed official within the town of Minturn, your relationship to the community changes? Agree?
Agreed.
Yeah. I mean, particularly to those in the know, right? But yeah, you're no longer just a citizen, you're now a government official. And from a certain perspective, that's a 24/7 job, right? Please have a personal life, please enjoy it, but recognize in the eyes of your constituents, in the eyes of that group of the citizens that takes an acute interest in the goings-on of your board and commission, they're always going to perceive you to be a representative of the commission, a representative of the town. That's true in any context, right? You probably have a lot of great summer events. You know, you're down there on a Saturday with your family at one of these summer events, and somebody who's in the know knows that you've got some fairly high-profile issue coming up before the commission, and they see you over there at that town picnic. I'm going to go talk to that commissioner and tell them why they ought to vote no or yes or this or that. Well, the hat was never off, right? From that perspective, and you know, as they should. As at the end of the day, what do you got? How many citizens are we at? Up to
About roughly 1,100.
1,100. Of that, we got 7 members of the city council, and you've got 5 members and 2 alternates. Is that right?
5 members and 2 advisory board members.
Yeah. Population of almost 1,200 people. There's only 14 people that get to make these decisions. That significant.
Planning and zoning.
And planning and zoning as well.
Yeah,
Yeah, 21.
Another 6.
Yeah. Only that small group of people gets to make these very important decisions affecting people's property rights. So, as they should, our words, our deeds, our conduct matters in any context, fair or unfair. You know how it is. There's a newspaper around here, sometimes have run stories about the personal conduct of elected or appointed officials. Sure they do. Why did they take an interest in that? Because you're an elected or appointed official, right? They just love that stuff. It gets the amygdala going. That's what the news is all about, right? Yeah, so that's why they look for that stuff, and just remember that it is a 24/7 job in that aspect. And the other aspect, more risk-wise and legally, is once you become an appointed official, the nature of the relationship is that you're a fiduciary, right? And that's the legal concept by which it's your obligation as a fiduciary to put the public interest and the interest of the town as a corporation above any other interests, right? Your niche is a little narrower because most of your decision-making is guided by very clear, well, do you agree, very clear or very specifically articulated standards, right? So you got good guideposts. Council's got a much broader policy-making array, but they have the same fiduciary responsibility, right? Their job is to be good stewards of the interests and assets of the town. You'll fulfill that role sometimes, like when you're working on the historic preservation plan, what's in the best interest of the town as a town or the long term. That's kind of fiduciary lens. And you want to have those glasses on when you're thinking about the big policy things that you do as the commission, despite the tug and pull. You may be working on something to the comp plan, and this is odd. We don't usually get that many people in the room, but tonight we got a packed house, but that means we only got 20 citizens joining us. But boy, 3 or 4 of them are just really, really vocal about doing this one little thing in the comp plan. Why is that? Is that in the best interest of the town? Is that in the best interest of the town's overarching goals, right, related to historic preservation and the balance between preservation and property rights and that kind of thing? So using that broader lens sometimes is going to be helpful to you as well. All right. I think I touched on all of this stuff on the second slide. We talked about authority and so on and so forth. So the primary thing I want to talk about, looking for the new folks, but a refresher, is we're going to talk about quasi-judicial decision making. So let's go to the next slide. We talked about this last fall, but it's a great, what an interesting job as a commission, because you're going to work on some policy stuff, like the historic preservation plan, and the exercise you went through last fall on updates to the design ordinances and the general legislative rules, right? But a lot of what you do is you play the role of judge for specific applications that come in front of the commission, right? So if we back that up just a little bit, I guess that means your responsibilities on the HPC can be divided into 2 broad categories. You do some big picture stuff, right? Like adopting or making recommendations on it. Are you the final step for the historic preservation plan, or does it go to council?
Council.
So you make that recommendation, but you do all the heavy lifting.
Yes.
And then they say, great job, and they approve. Right?
Or not.
Yeah.
Hopefully.
Oh, right, yeah. And then whenever there's amendments to the design criteria or the landmarking procedures or landmarking standards, all that policy making stuff, you make recommendations on those too, right? Okay. So that's kind of the big picture stuff. When you're doing that, you don't have any specific applicant in front of you. You're just making general policies and general rules that apply to everyone in general and no one in particular, right? And then on the other hand, you do make decisions or recommendations on decisions that affect individual property owners or developers. Or alteration certificates, do you make the final decision?
Yes, and then it's ratified on consent to council.
Okay. Okay. And what about demolition holds? Yeah, that's just a hold to get you to the landmarking process, right? And then you make a recommendation on the landmarking or the final decision?
They make the recommendation on the landmarking, but they don't have anything to do with the hold. That's
Okay.
staff.
But for both those procedures, the alteration certificate and the landmarking, you're sitting in judgment. You're acting as judges. You have a specific applicant. So that's a different situation where you're making individualized decisions, right? And so for those individualized decisions like landmarking and alteration certificates, you're in what's called quasi-judicial mode. And that's true even if you're not making the final decision, like on landmarking, right? Your role, your part in the process is to be the judge, right? Think of it as we're holding the mini trial. We're gonna hear all the evidence. We're gonna make a determination, and that's basically our judgment that ends up being a recommendation to the council, okay? So that's the quasi-judicial role. Let's just break this down and compare it a little bit, because I wanna cross that bridge and show you how it influences the expectations around your own conduct. Okay, when you think about policy making, let's go to the next slide. You think about policy making, that's what most people think about when they say, oh, I want to be an elected official. I want to make policy for the town. Right? They don't think, oh, I want to run for office because I want to be a judge adjudicating individual, you know. It's usually the more intuitive part of the job. So from a conduct standpoint, for legislative activities, right, certain things are just fine. And all the behaviors that I've listed here in red, if you compare, like some of the things that the town council does that relate to your work that are legislative in nature are things like, hey, should we have a historic preservation code at all? That's a legislative. Right. Should we amend the design guidelines for historic properties to require an additional set of standards around windows? That's a policy issue. It's not being applied to anyone in particular. And when you're hashing out those kind of policy or legislative discussions, look at the things in red. You can listen to citizens who contact you in person or by phone or email or social media. You can investigate those issues yourself, right? You can lobby and be lobbied. You can talk to citizens in the grocery store about that issue, right? You can work, as long as you comply with the open meetings law, you can work to build consensus around a policy perspective. That all sounds like the things that the legislators do, right? And all of that's perfectly permissible. And even when it gets to you're finally ready to take that vote on those recommended changes to the design guidelines for window casements or whatever, and you can vote based on your own personal preferences and perspectives. You can say, I just don't like this ordinance because I don't like the design elements that we're introducing or potentially introducing in our historic properties. I don't care what anybody else thinks. Personally, I just don't like it. I'm going to vote no. I'm clearly voting because of my own bias and personal preference. That's just fine on legislative matters, right? But let's go to the next slide. With respect to quasi-judicial matters, that's not true, right? So you're in legislative mode when you're making or recommending the historic preservation plan or making or recommending changes to your generally applicable ordinances. That's the big picture. That's where you're visioning. But when you make decisions concerning a specific property rights, that's when you're in a quasi-judicial proceeding. That's where you need to switch your mode of thinking and your mode of conduct to say, I'm not in a legislative mode. I'm not a legislature here. I'm a judge. Collectively, we're a group of judges. Let's go to the next slide. Okay. So the kind of good acting, working definition of a quasi-judicial matter is a decision that affects the property rights of someone at an individual level, where the decision is made on the basis of specific criteria, right? Our landmarking standards or our alteration certificate standards. Those are standards that were put in place previously. They're pre-existing legal criteria that guide our decision. We have to make our decision based on the testimony and evidence that people present to us at the hearing. And the decision has to be made by a fair and impartial decision maker. What's that all sound like? That sounds like a trial. It sounds like the things that judges do, and it's exactly what it is. We call it quasi-judicial. The law calls it quasi-judicial, right? And that's what you're doing in this situation. Let's go on to the next slide. Okay. We're going to get into the actual ways that you have to change your behaviors in just a second. That all sounds sort of weird. You're like, well, I didn't know that I had to be a judge, and I didn't know I had to act and think like a judge when these things are in front of us. What do you mean? Where does this all come from? It seems very mysterious, but when we recognize where it comes from, we understand why the expectations are different, right? The rules of engagement for quasi-judicial decision-making are premised on that phrase we all know, no person shall be deprived of life, liberty, or property without due process of law, right? So the grand bargain here, and this is a nice thing in Colorado, it's not true in all states, we want local control, right? We want local control of land use. We want the town of Minturn and its citizens, through its appointed and elected representatives, have control over our own placemaking, our own destiny, right? But if we want that power that the 20 or so of us have, the grand bargain is that we have to make sure we exercise it consistent with people's due process rights under the federal and state constitution. So that's the whole grand bargain that we're going to unpackage here, okay? Due process at its essence means that if we're going to make these decisions that tell people, yes, no, you can or can't do this with your property, we have to do it, right, through a process that provides for a fair hearing in front of an unbiased decision maker who makes their decision based on pre-existing legal standards. That's it. That's it. Hope I did a good job in summarizing the millions of pages that are written about what due process means, right? That's it. So we're going to start unpackaging the rules, but remember, please give your attorney and staff some grace on these points, because we're not trying to be obstinate here. When we say we want you to follow these rules of engagement, what we're trying to do is protect your role and your responsibility, frankly, your ability to participate, right? Because if evidence ever came in, and I don't mean in court, I mean if evidence came in just around town before or during one of your public hearings, that one or two or some of us were not following the due process rules of engagement, then the angry citizen or the angry applicant or somebody else who's got an interest in the application, they have every right to raise that issue at the hearing and afterwards and say, hey, this person is biased. They shouldn't be participating. Well, and then the chair's got the responsibility of, all right, hold on here. What are we going to do now? I got somebody standing up saying that, hey, that Dan shouldn't participate because he's got a conflict of interest. That's a violation of my due process rights, right? So those things can unfold in the moment. So when we say, make sure we want to follow all the due process rules of engagement, we want you to remain one of the 7 people that does get to make the recommendation and does get to make those decisions, right? But if we, by our own behavior, take ourselves out of the game, that's kind of frustrating for you, right? And it's frustrating for the expectations of the council that appointed you, right? And the citizens that put their trust in the 7 of you to be their experts on these issues. So we need to make sure we follow those rules, right? And then the other thing we're doing is when we recommend these things is to protect the decision that you ultimately reach, to make sure that it's not subject to attack because there's some taint because of a due process problem that was raised by the behaviors of an individual or a couple of individuals. The classic example is, it's a close vote, it's a 3-2 vote, and lo and behold, it turns out that 2 people who voted on the 3 side to turn down the application had undisclosed conflicts of interest. Do we have a process problem now? Absolutely. Is our decision subject to attack? Yes, the decision is subject to being overturned. Are those individuals subject to being on the receiving end of an individualized ethics complaint? Yes. Right. So that's sort of the downstream bad things that can happen. Okay. So let's talk about what the rules are. Okay. Oh, by the way, I mean, isn't it interesting that all this is, we haven't really talked about the substance of your decision. We've been talking about process, right? The legal risks lie around process, not around substance. And I'll explain it this way. Let's say somebody didn't like your decision on an alteration certificate, and they're gonna sue you, they're gonna legally challenge it. And their theory in district court is, judge, reverse their decision because their determination that the proposed replacement windows for the historic facade were compatible or were architecturally appropriate is arbitrary. The district court judge is gonna look at that, right, and go, you imagine a district court judge doing this? Well, yeah, I know a little bit about windows, and I like, Pella or this or that, and so, I don't think those windows work right in Minturn. So you're right, I just don't like them. I'm gonna reverse their decision, because I don't think those were the right windows for downtown Minturn. That's not the judge's job. It's the judge's job to police process, though. The standard for defending your decision in district court is the judge is obligated by law to uphold your decision, the substance of your decision, as long as there is any competent evidence in your record, right, that serves to support your decision. So yes, you could have had a 3-hour debate about the appropriate window material, but if you all during your deliberation said, look, I've looked at our standards, I look at our code, I hear what everybody's saying, and for these reasons, which are logical and appropriate reasons, I decide we're gonna go with this, then it's defendable. You win, right? But judges will police process. Like, if you didn't give proper notice, or you didn't allow evidence into the record, right? Or you failed to disclose a conflict of interest, right? Or you told the applicant after somebody stood up and gave you a bunch of blockbuster information when the applicant said, hey, can I ask some questions about what they're saying? Because no, we don't want to hear any more from you. Right? Well, you're taking away their fundamental right, right, to be engaged in the adjudication of their case, right? So the good news is we almost always win on substance, right? And as long as our process is good, then we win all the time. But if we create procedural problems, that's where somebody can go looking for something like a civil rights violation. Okay. Just recognize, obviously this is a truism here, you don't wear a robe, right? And you're easily recognizable. Let's go to the next slide. But essentially the quasi-judicial job that we have, you and the Planning Commission and the Council, when you're looking at these individualized applications, is that, let's go one more slide. You have to get in that judge courtroom mindset and make sure we do the things that judges do and don't do the things that judges wouldn't do. Okay, let's go to the next slide. So here's just examples. One of my handouts breaks these down a little bit more. So the job requires us to think like a judge. So don't make up your mind before the hearing. Don't make any prejudicial pre-hearing statements, which I know can be a frustrating thing, right? I'll give you an example from elected officials. Maybe the elected officials are downtown core. Let's say, some municipalities, their philosophy is, well, we like appropriate growth in the downtown, we like appropriate businesses, but we prefer they be retail sales tax generating, right? And we support some local community-owned stores. But darn it, yet again, here's another application for a bank, right? And so, but the bank requires approval from the elected officials or the planning commission, or if it was a historic building, requires approval from you all. And the newspaper gets a hold of you and says, hey, I understand there's concern out there in the community about another bank. And then you say to the newspaper, yeah, I will never vote in favor of another bank located downtown again. Does that sound like a fair and impartial? No, you're just taking yourself out of the game. The applicant or the people who know which way you're going to vote, they're going to bring that to the hearing and say, hey, you can't participate, you're biased, right? So there's a lot of nuances around that issue, but that's the general concept. Make sure that you don't speak with one side or the other before the hearing. We're going to break that down in a minute. On the code of ethics, just make sure, I like what you said earlier, Chair, right at the beginning of the meeting. You've got that opportunity for disclosures. My only suggestion would be, is that a disclosure that you do also at the time of individualized hearings?
No, we require them to do it all at the beginning of the meeting.
Okay, so if at 5:30 we call the meeting to order and we say, yes, I have a disclosure I need to make. I have a conflict of interest with regard to the certificate of appropriateness that's coming up later because I happen to be the next door neighbor. And I think that what they're doing is going to impact my views or my property value, so I need to recuse myself. So you said all that on the record at the beginning of the meeting. When you get to the actual hearing and open the hearing, make sure that that point, that disclosure and recusal gets on the record for the hearing as well, right, at the later point in the meeting. So you can do it just saying, okay, next item on the agenda is the certificate of appropriateness for 101 Main, and then you do something to make a record that Commissioner Sam is recusing himself as for the reasons previously stated during the disclosures, right?
And when they recuse themselves, is there a formality there as well for them at that moment? Do they need to?
Yeah, you're home rule and you've got your own local code of ethics. So it might have some specific requirements that I'm unaware of, but here's my basic suggestion, which is built on the state code. If you have a conflict of interest, disclose on the record, right? Do it before any discussion. I've seen people, they participate in the entire discussion, then at the time of the vote, they say, I abstain. Why are you abstaining? Because they have a conflict. Well, it's too late, right? So disclose, abstain from the commission's discussion and vote. And then, this is where you need to check your own code. But most codes of ethics also say that once you've done all that, you're also prohibited from attempting to influence the decision of the other commissioners, okay? So when you make your disclosure, I would.
Question in that regard. If you're the next door neighbor and you're a witness representing yourself, can you then move across the room and represent yourself in that role?
I would ask your town attorney on that issue about what that is about.
We severely discourage that.
Yeah, I would severely discourage it. I don't know what the legal rules are, but here's the reason I severely discourage it from across the board standpoint, and I'm going to borrow from the state code. And yours might have something similar. Does it have a non-influence provision?
I'd have to double check.
Yeah, so if you have what's called a non-influence provision, here's what happens. You do everything right. You make a public disclosure, you don't participate in the commission discussion, you recuse yourself, but you're still subject to a legal rule, fair or unfair, whatever, it doesn't matter, it's the law, that says thou shalt not attempt to influence the other decision makers. So you step down, recuse yourself, you go back here, right? And then you start advocating, and is that improper influence with respect to your interest for which you hold a conflict? And you say, yes, I guess it is, but I have a constitutional right to protect my own property rights.
It puts us in a difficult situation too, because we know that person, we work with them.
Yeah, I do think my own view of this is one of those areas where, remember, it's just part and parcel of being an elected or appointed official. That if you want that higher power, you got to submit yourself to the rules that say if you hold that higher power, you've got a higher standard. Everybody agree with that notion? Elected officials, appointed officials are held to a higher standard. You're in conflict of interest. We can grouse how much this affects my own personal interest, but if we're on the commission, we're still subject to the state code of ethics. So I think the solution to that is to get someone else to do your speaking for you. Yeah. Right?
Like your spouse or?
Yeah.
Somebody to make sure you're.
Or if it's your own property and you're the one that needs a certificate of appropriateness, you recuse yourself, step aside, do you leave the room? Right? And then when there's questions for the applicant, you have your spokesperson speak on your behalf. Takes you out of that crossfire. I have seen ethics complaints filed under the state code of ethics against, it's sad, the person did everything right, but they stayed behind and they answered questions, or, and maybe you can get away with that. I mean, yeah, I've got a question for the applicant. My question is, what's the size of the lot? Oh, that's easy. That's objective. It's 6,000 square feet. So you answer that question. It's 6,000 square feet. Oh, and by the way, you're going to love the project. You're going to have a nice, cornice on the top and wonderful windows. And does that sound like influence all of a sudden? And somebody used the idea of people just going after you. It doesn't matter if they're motivated by political animus or they consider themselves to be a government watchdog. You can't control the reasons that someone might file an ethics complaint. If they think they've got credible grounds to make one, and you do have a non-influence rule, that's just a risk that I'm trying to identify for you. So I encourage you to use a spokesperson to be your zealous advocate on your behalf, but take yourself out of the crossfire from that potential exposure by having somebody else do your speaking for you.
Madison, is our practice when somebody does have a conflict, do they leave?
They leave the dais, they leave the room.
They leave the room?
The only time that we do not enforce that is if they themselves are the applicant.
Yeah.
We don't make them get a different representative for
Right,
their own
right.
application.
Right.
So they can sit over there, but
So
they can't sit here.
they cannot sit on the dais.
Right.
But if, let's say you have a financial interest in whatever's going on and you do not have, but you are not actually part of the application or or whatever is actually being talked about, we do require you to leave the room.
Yeah. I think that's
You can
appropriate.
go through and join on Zoom and watch on Zoom if you
Yeah.
like, but you can't participate in the
Nothing
discussion.
against you, I understand your motives.
Yeah. So
But let's say
typically-
that we know that that individual has some conflicting interests and yet they've decided not to identify that. What is our recourse?
Another question for your attorney and staff.
Okay.
So
Yeah, 'cause I got,
You would come to me, I'd go to her.
yeah, among the landscape of our members, we have 294 members of SURSA. We insure about 90% of the cities and towns in the state. Some of them have either charter or code provisions that say the board or commission, by a vote of its members, can require that another member recuse themselves. They can make a determination as a board that the person is.
And we have that.
I've seen that
So-
happen with town council.
yes, if the board as a whole or a majority of the board believes that the person who's conflicted is not stepping down appropriately, they can vote to have them recuse themselves.
Yeah, and the practical approach to that sometimes, we don't want to weaponize the rules and we're not looking to embarrass people. We're all working collaboratively to do the right thing and all stay out of harm's way, right? And so sometimes it's, can we have a little recess and then the chair or staff can talk to that person and say, hey, look, this is the issue. Again, it's your call initially, but if you want to do this, I bet what's going to happen is the board's going to put it in front of the board and they're going to deliberate it and have a vote. And the person said, that's fine, I get it, that's the process, we'll go through the process and I'll submit to whatever the vote is, right?
Right.
Yeah. Okay. All right, a couple more things, you probably don't get these, but if you ever have one of those situations where somebody shows up with a petition, other than the petition to landmark a property, but it's like you get one of these petitions from the neighbor that says, we the neighbors encourage you to vote no. Well, you don't want to be signing those. And then on the downstream side of that, you also want to get together with staff and say, what's the evidentiary value and credibility of these? Because it's a common urban legend in the municipal world, the local government world, that if I somehow show up with a petition signed with a lot of people, then that's going to make it so. But land use decisions, property rights decisions are not popularity contests, right? They are decisions that are driven by legal standards. So as an example, if you have a certificate for appropriateness that's filed and the applicant has checked all the boxes, done everything right, and all the evidence points to yes, but nonetheless, we have a petition that was turned in by 200 citizens that says vote no, where's the evidence leading us? Yes. The petition has no probative value. It's nice to know people are upset, but we can't go down a different path than where the evidence points to, right? Because of those issues. It's tough. It can be tough in those dicey situations because you feel like you're on an island, The entire room's like, vote no, or the entire room's like, vote yes. And your evidence and your whole, this framework that you put in, work so hard to put in place, everything within that is telling you vote the other way. It can be a little tough. So if you ever face that, a good thing to do is whoever staff can help you with this, you can get staff to help calibrate and just remind people, hey, look, this is a rules-based decision. We appreciate everyone's passion and emotion around these issues, but we as the commission, we have to look at it through this lens. Staff, can you remind us all, how we look at these issues? And that can help take some of that pressure off. All right. Last thing I want to point out here is make sure you don't bring to the hearing facts that you know to be true, but that aren't part of the testimony. That's the idea. When you're the judge, you don't want to be a witness in your own hearing, right? You just want to sit back and have people bring you information, right? So you don't want to be a witness, you don't want to be the prosecutor, you don't want to be an advocate or the investigator, you want to hang back and be the judge. That's a great spot to be, because you're like, hey, I just get to sit here as an impartial neutral, listen to all this, and then I got the power to decide, right? But do that with a judge-like demeanor and role. Okay, let's go to the next slide. A couple other things, make sure that you only discuss quasi-judicial matters at the commission's public hearing. That can be a little frustrating, right? But you have to, as the judges, you have to stay above the fray and not get involved in the conversations around the application outside of that hearing process, right? But yeah, it can be frustrating, just like my earlier example about the newspaper reporter. If there's a controversial application coming up in front of the commission, what's the natural inclination of the citizen? I need to talk to the commissioners sooner than later and tell them why I think they ought to vote yes or no, right? But you don't want to engage in that. Let's say the neighbors who are adamantly opposed to this project that needs your sign off, they want to have a little community meeting to work on their strategy. Should you be going to that? No. Let's say the applicant, is concerned about all the money they're putting into this process to give all of the designs and all of this. So they want to meet with you and get a sense of whether this thing even has a chance. Right? That's a fair developer perspective. And like, I'm about to put all this money into it. I want to know if am I going to have your votes? Right? Ask yourself this, would any of that be fair if it was your application? Right? Would it seem fair that the people who get to decide the case were meeting with other people for strategy meetings or having conversations before the public hearing, right? No. Sounds a little weird, but everything has to happen within the public hearing. Yes?
I kind of got a pretty decent example of that. When I was the building official for Macon, Georgia, we've got what's called the Big House, and that's where the Allman Brothers lived. Big deal where I come from. I don't know what it's like here. Or not that much of a big deal from what I'm seeing. So back home, it's a really big deal, and they had a property that was adjacent that they claimed was historic.
Yeah.
Yet most of the claims of it being historic were kind of hearsay. We didn't have any kind of documentation or whatever, but the owners and the, we'll just call them managers for lack of a better term, of the Big House were constantly in my office.
Yeah.
Trying to persuade me, but you know how much this means to Macon, and if you'll let us do this, it's gonna expand upon our influence and this, that, and the other.
Yeah.
And like, I had no choice but to stick to the guns. But I guess the only reason I'm saying it can be incredibly difficult to say no sometimes.
Yeah. And were you the staff member or were you the decision maker?
I was the building official. I was the decision maker.
Yeah, so yep. Okay, we're gonna break that down a little bit more in a slide or two. Let's go to the next one. Just want to show you some examples of things. These are both from real life scenarios that kind of show the pickles that we can get into. Even sometimes, we think it might be with the best of intentions, but here's one. So we recently recommended approval of an alteration where the owner plans to create a shared driveway with the neighbor, which will allow the applicant to move the existing driveway, create more room for the addition. Yeah, that's going to expand the home. It's going to impact portions of the historic facade. That's why it came in front of you, right? So we're having this hearing and we're talking about the building footprint and how the facade's going to be affected by the addition and so on and so forth. And one of us, our idea is like, well, look, if you can't get the easement, you're not going to get the approval. Does that sound like now getting involved in that personal issue of whether or not I can get an easement, right? So after the hearing, it ends up being a 3-2 vote, and one of the commission's okay, it met all the standards for the appropriateness certificate. And now one of the commission members who voted no, right, goes to the neighbor and is trying to convince the neighbor not to agree to the shared driveway. Is that commissioner doing that with their commissioner hat on?
No.
With their commissioner hat off? What do you think?
Absolutely off.
Yeah.
It's not a neutral
I
position.
don't even think he has a hat.
Yeah, I mean that we, as from a coverage standpoint, have the same sort of questions of like, is this an allegation against this person as a commissioner or as a private individual? But nonetheless, the person was being sued for tortious interference with prospective business advantage, which is a recognized tort in Colorado. If you know someone either is on the cusp of or has some potential for financial or business gain under contractual arrangements or other legal arrangements that are already in place and were intentionally and wrongfully attempting to take away those, that's the tort of tortious interference. I'm not sure if this constituted tortious interference, but we had to deal with the claim. The complaint was filed against the individual, right? And got resolved without a trial, so we never had to decide whether or not the person was acting in a personal or official capacity, right? The claimant had to cover their term. They made allegations in both capacities, right? So that one, you have to be careful of that. You have to remember that that proceeding was just before us, the day before, when I was wearing my hat as a commissioner talking about this easement. Am I really getting myself away from potential risk there? And if I am I willing to accept the personal risks, right, of being a party to this transaction that created the legal entitlement? After all, he has an entitlement to go to the building department with the understanding that as long as I get the shared access, I can get my building permit. And now somebody who's on the inside is attempting to take away the entitlement that the entity just gave me. And that was the allegation.
I have a hypothetical question about
Yes.
that though. Just, let's say this person who voted no, like,
Yeah.
is really, really adamant that this is like a wrong. Would their best course just be to resign? Like, if it was such a conflict of interest for them?
Oh, I don't know. That's a personal decision, but I'll be frank. I mean, if the choice was I either resign or I'm going to do things that put the commission and the city at risk, then I'd say I suggest you resign, right? I mean, the choice is not to, do I have a license given this power to do things that are going to get me or the city in legal trouble? I'm being kind of glib here, right? But yeah, if you're posing the choice of, well, I'm either going to resign and protest or I'm going to do things that are going to potentially lead to legal liability against the commission or the city, then if it were me, I'd say, well, I would prefer, as giving you advice in your official capacity or the town advice in their official capacity, I would suggest that you take the resignation course because I'm trying to protect the entity from liability.
I can actually give you a super small example.
Yeah.
So we had like somebody who was on the Planning and Zoning Commission and they were also on the Preservation Commission, but they lived in a historic district, right? And so a lot of the things that were coming, there was so much frequency of things coming along that they had to just leave. They couldn't do it anymore.
Two things.
So
I'm that person. I was told I was allowed to do this.
Yeah.
As long as I only chose to vote in one area. So I had the right to recuse myself here and do my vote at planning and zoning. The other thing is, in something like that, it would depend on what the code allows. If the code is going to allow at planning and zoning for that easement,
right.
You've got your regulation there. And if you're on planning and zoning, as long as it follows the regulation, it should be allowed.
Yeah. And again, we didn't get to the merits of this, but in this litigation we had, but the person's basically saying, well, don't I have a right individually to say my personal opinion? And if so, if you're going to do that, make sure your personal opinion is stated as your own personal opinion. Recognize that if this plaintiff, who thought they had a winning theory, who actually won on that theory, there would be no defense or indemnification from the entity because it'd all be personal conduct, right? So. All right, the second scenario, from prior comments, it seems one of our members generally disfavors any alterations that replace historic elements of wood with synthetic materials. We have an upcoming hearing that proposes these kinds of changes, and the member has been asking staff to include in the packet detailed information about the inferior quality and aesthetic of faux historic elements. He's also been posting on social media about the upcoming hearing. What do you think? Concerns?
There's a whole lot of worms going on there.
So as the judge, as the judge, your responsibility is to listen to the evidence that's presented to you. Doesn't that activity sounds a little bit more like advocate than judge, right? Now, but sympathetic to this member, maybe there are legitimate concerns about the quality and aesthetic of these materials. But how do I get that issue, right, in front of me in front of the commission the right way?
You gotta draw it out of them.
You raise questions,
Yeah.
you raise questions, right? So instead of, like this would be what you want to avoid. You don't want to be, as the judge sitting up here saying, well, I'm going to deny this application because through all my research, I know that these materials are inferior and not aesthetically pleasing. Therefore, I make a motion to deny this application based on the wonderful testimony of me. Sounds a little jacked up from a due process standpoint. But the way you get there is just by asking questions. Maybe you're frustrated because the applicant's been evasive about whether this is quality material, and staff needs more time to research because they just turned in the materials board yesterday. So it's your right to say, hey, staff, applicant, could you tell me more, what are these materials? What are the actual materials being involved? Is there any data that shows how they stand up to our types of weather conditions? Right? Do they fade quickly? Do you have information, data you can present to us on what happens to the colors? Right? And it's your right that as long as you want to ask questions that relate to your criteria. But that's how you flip that around, right? And not get into the difficult situation, but get the information that you need.
So you make inquiries so
Questions.
that
Yep.
the others can be informed of.
Yeah. Yep.
So
you
when-
direct-
From the
You'd be like,
source.
what's the current state of the materials
Yeah,
that are in
direct it
use?
to the
Can they
staff
be
or the applicant.
resolved?
Make sure you don't ask leading questions. Now, sometimes maybe it's the chair's best position to deal with it. Sometimes the question is, so yeah, I know about these window materials, and is it not true, applicant, that these materials are inferior and they are worthless after 1 year at our altitude and sunlight? That sounds like a leading question. Maybe the chair's saying something like, wait, before you answer that, let me make sure I understand what the question is. Commissioner Sam, aren't you asking the applicant to give us information on the durability of the material given our altitude and weather conditions? Oh, yes, that's what I meant, Chair. Thank you so much for helping me out. And now I sound more judicial rather than like an advocate, right? And that's kind of a nice place to be.
So what do you do when you think that they're lying about their presentation and you have more, you have experience with those, but then they say when they're presenting like how wonderful this is.
Yeah. So your
But then
staff,
otherwise.
ask your staff, right? And I suppose we're getting kind of close to some issues that I really should suggest town attorney advice on, but I would suggest something like this. If you know it, we can't come to these things as a clean slate, but we can turn to staff and say, look, I hear what the applicant's saying, but isn't there other research out there? I heard of this study. I've heard from the manufacturer's spec sheet. Is there any way we can get the spec sheet and look at that, right? And ask for that information to come into the record, right? When it's all,
We could ask.
Yeah, what cures the ills is as long as we're treating it like a question and we're getting the information into the hearing record where everyone can test it and speak to it, then we're taking care of any due process problems that arise.
And we could continue it if we needed.
Yeah.
Right.
Yep.
That we could do that.
Yeah.
So we could
Yeah,
get more
you just-
information.
Yep, yeah, you just don't want to become an investigator in between meetings as well, because then you're back into that.
But we're not gonna bring the information in.
Yeah,
Our
the
staff.
staff. Yeah,
Yes.
before we go, we're gonna continue the next meeting and, okay, and so for the next hearing, staff is gonna bring us more information on the manufacturer's spec sheets. They're gonna bring us any information they have on the durability of the materials from credible sources. Applicant, please, if you have the information the same, anybody else wants to bring information on the same topic, we'll pick up at the next hearing, and one of the primary topics we'll address first will be further information on the materials that are proposed. And now you're in a good spot. Yep. Yeah, don't be an investigator in between. I just, for levity, I'll just tell you one funny story. It was a council level one, but the whole issue was traffic impacts. And the member was skeptical of the staff's traffic report and skeptical of the applicant's traffic report. And there was citizens were providing testimony that said, I don't care, the citizens were basically saying, look, I don't care what the traffic studies say. If you put another left-in turn in there, that road is gonna be gridlock. I'll never be able to turn, right? So they, after
I've heard that.
an hour or more of this kind of,
Some meetings here.
hour or more of this kind of testimony, they continued the hearing, and the elected official showed up at the next hearing. He said, you know, as I said during the first hearing, I think there were flaws with the staff traffic report and the applicant traffic report. So since our last session of the public hearing, I've done some of my own traffic counts. Good idea. Not a good idea. Not a good idea. He could have had staff, he could have said, and you know, he had a valid criticism. He's like, hey, wait a second. I don't see that the staff or applicant traffic report has counts during peak hours. So now last thing, and it's a question, is that a criteria? Does our methodology under our regulations require that you count peak hours? Or is it average across the entire day? Or what's the methodology, staff? That's when you turn to staff to help you out, right? So that kind of thing comes up sometimes.
I'm gonna go use the restroom.
Okay. Let's keep rolling. I think I had on an earlier slide, next slide. Ex parte context, from a due process standpoint, one of the key duties of a judge, quasi-judge, is to make sure we avoid outside of the hearing discussions with any of the interested parties about the material issues that are the subject of the hearing. It's all just premised on the idea that we're going to be talking about somebody's property rights, and everybody who's an interested party has the right under the due process clause to hear everybody else's testimony and provide their own responsive testimony if they want to, right? So, ex parte communications, right, we just need to avoid those, right? And I gave you a couple examples that I touched on earlier of things that are ex parte communications that wouldn't be appropriate for you all as the judges, okay? So, going back to my earlier comment, when we in the town attorney and staff remind you, hey, don't engage with the applicant outside of the hearing, we're again just trying to protect your ability to stay in the hearing. We have had hearings where at the beginning of the hearing, the chair opens the hearing, and then someone stands up and says, hey, I'd like to make an objection. I would like Commissioner Sam to recuse himself because I know, and I have the emails to prove it, that he's been communicating with the neighbors or the applicant or this or that, right, with them about the decision that he's being tasked with making this evening, or he's been talking about the application. Okay, so we need to stay away from that and control it as best we can. Sometimes we do the best we can, but it still finds its way towards us. Like the applicant or the assistant sends you an email at home with all the reasons why you ought to vote yes or no. What do we do with that email? We just send it to staff. Yeah, we're going to get it into the packet, right?
Yep.
And now the ex parte aspect of it has been cured because what they were trying, that information that they were trying to provide you outside of the hearing is now in the hearing record for everyone to see, right? Same thing if someone tries to approach you at the store, right? So reminder, you're all great ambassadors for historic preservation and for the commission, and people in the know that. But if it's an application, we have the same issue. Let's go to the next slide. So if they try to bump into you somewhere and, let's go to the next one. It's not that we don't want to hear from them. We would love to hear from them. But if they try to corner you at the, I've forgotten the name already, the Minturn Country Club? Try to corner you at the Minturn Country Club to debate this certificate application that's coming up. You need to have your talking points and say, hey, look, not that I don't want to hear from you. We'd love to hear from you, but as the decision maker, I can't debate this application with you or talk to you about it here in a restaurant. Okay? Again, we'd love to hear from you, but as the commission, we got to protect the town. We got to protect ourselves. You understand that, wouldn't it be? You know, if it were your application, dear citizen, do you understand that? And usually they go, yeah, I get it, right? I get from their perspective that they can feel exposed standing up in a public meeting and saying their piece, right? Particularly in this day and age, right? But remind them, hey, we'd love to hear from you. If you can come to the hearing, please do. If you can't, you can send an email to staff and we'll all read that as commissioners and we'll consider your views when we make a decision. But we don't want to be in a situation where it's occurring and it's not disclosed. Because that's where the surprise moment comes, and if it's happening and the evidence supports that it's happening, then as a matter of liability, your town attorney is definitely gonna suggest in an extreme case, you've gotta step away, right? Because it suggests you've been engaging in inappropriate communication. All right. The other resource we see that members have that sometimes helps is
Question, so, we are eligible as